Tonight on Nation to Nation, a legal expert weighs in on an upcoming Supreme Court decision on Quebec's challenge to Canada's Indigenous child welfare legislation.
So it is an advisory opinion. It's not going to be something that could strike down the Act.
University professor Ken Coates talks about why the word treaty is included in the federal government's new Métis government's recognition legislation.
If you don't have a treaty, what you have is an agreement. And if what you have is an agreement is subject to political processes, to sort of being defunded down the line.
And a First Nations doctor talks about the importance of including a cultural component in Indigenous youth mental health initiatives.
It allows them to hold their heads higher, to acknowledge where they come from, acknowledge their language and their ancestors.
Welcome to this week's episode of Nation to Nation. I'm Fraser Needham. On Friday, a major Supreme Court decision is set to come down on Bill C-92. It's the federal government's legislation that gives Indigenous communities control over child welfare services that affect their children and families. The Quebec government has challenged the legislation, saying it infringes upon their provincial rights, and appealed the case to the Supreme Court of Canada. Joining me today to talk about the case and what tomorrow's decision may mean is Hadley Friedland. She's the academic director of the Wet'suwet'en Law and Governance Lodge at the University of Alberta. She joins us today from Edmonton. So welcome to Nation to Nation.
Thank you for having me.
Right, so first off, maybe you can tell our viewers a little bit about what the Supreme Court will be deciding tomorrow and what its significance will be.
One of the things that's important is this is a reference case, so it is an advisory opinion. It's not going to be something that could strike down the Act, like some of the cases we hear about. So, but it will be very persuasive what the court decides, and there's three possibilities really of what can happen. The court might come out and say the entire act is constitutional. It all was within the federal government's power. They might say parts of it are constitutional, parts of it aren't. Or they could say all of it would be unconstitutional. And that would obviously result in different consequences.
Yes, and I was wondering, it's fairly clear, I think, my reading of it, that what should happen in a sort of an Indigenous community or a First Nations community with child welfare services. The government has sort of said this, they want these communities to be handling child and welfare services, and that's what they want. But I wonder, how is the legislation or your interpretation of it supposed to work, let's say, for many Indigenous children and families that don't live in their home community, like live in large cities like Edmonton, where you are, things like that, where it is actually, the child welfare services come under the province and they pay for them largely. How is it supposed to work in those situations?
That's a really important question. One of the things that happens with this act is people really focus on the lawmaking part of it. But there's two parts of this act. There's the lawmaking part, that legislative authority. Again, that's not giving power, it's recognizing and affirming powers that exist. But the other part is the national standards, and these are national minimum standards that anybody, whether it's a province, whether it's a First Nation, needs to be following to meet those minimum standards for Indigenous children. And it includes, to give you an example, a similar act called ICWA in the United States only applies to children who are registered in federally recognized tribes down there. This act very specifically applies to all Indigenous children, Inuit children, Métis children, First Nations children that are living on reserve, off reserve, status, non-status. So those national standards apply. And also nations laws can apply. It's intended to be following the child, following the family, because we know children and families go back and forth. So it's something. It applies something we call personal jurisdiction rather than territorial jurisdiction.
Just turning to what may happen, let's say if the Supreme Court rules against what Quebec has challenged here. We've seen it in the past with Alberta that they like to use or threaten to use the notwithstanding clause. Of course, Quebec has used this for the Canadian Constitution as well. Would they be on any sort of solid legal ground if they did try to sort of talk about or use the notwithstanding clause?
The notwithstanding clause is something different. It would apply to a breach of charter rights, so people's individual and personal freedoms. This question is really about division of powers, about whether the province or the federal government has the power. So I don't see a space for the notwithstanding clause here. And one of the things that is important to point out is while there were interventions, Quebec is the only province that did bring this reference. Other provinces and territories made submissions that brought up these issues, but I think that's important to note too.
Yeah, I thought I might follow up on that as well. Of course, that Quebec is in court over this, but do you think other provinces will be watching closely and taking their lead from what happens tomorrow, or have they sort of decided the route that they'd like to take with the legislation already, and it will not make that much difference to what they do in the future?
I think this act is in motion, and in a lot of ways, it's showing what it's doing already. If I can give an example, there I said there's two parts of this act. There's the national standards and the lawmaking. There's 171 cases that we've identified so far since this act came into force in 2020. 169 of those are about the national standards. And the Quebec court did uphold those, and it's very likely those, even in the submissions in this court, those weren't questioned a lot. For the lawmaking, to give an example, there's a case out of Alberta and a case out of Quebec. After the Quebec reference case, a Quebec court upheld a First Nations law saying this is an inherent Section 35 Aboriginal right, and the provincial law would be an unjustifiable infringement. And the Alberta court upheld the First Nations law, saying it has the force of federal law under this act. So it's two different ways of upholding those laws, but also it gives you an idea of the proportions. So I think I don't think the sky will fall. Fingers crossed. I don't think the sky will fall tomorrow, no matter what.
Yes, I mean, the legislation's been in place for a while now too, and hopefully provinces, like you say, like BC, have already been kind of planning on what they want to do. So it really, provinces should hopefully have made some plans prior to this court case decision tomorrow. But we're going to have to leave it there, unfortunately, for time reasons. But thanks very much for talking to us today. It's a very big decision that, of course, you'll be following tomorrow, and we'll be following it too. And once again, thank you for joining us on our show.
Thanks for having me.
Next up, we'll talk to Yukon University professor Ken Coates and get his thoughts on Bill C-53, the Métis Government's Recognition Act that is currently moving through the House of Commons.
I'm Kathleen Martins, a reporter with APTN News. Homeless, houseless, shelterless people, they aren't hard to find in Winnipeg. They're on the sidewalks, in bus shelters, and down alleyways. They're living in tents and squatting in empty buildings. They're even sleeping in abandoned cars. But who are they? Hear their stories in my new 5-part podcast called Our Relatives. Listen on your favorite player.
You're watching Nation to Nation, and I'm Fraser Needham. Trudeau government's Bill C-53 continues to generate controversy. The proposed legislation aims to formally recognize Métis governments in Alberta, Saskatchewan, and in Ontario. First Nations in Ontario are opposed because they say the act will infringe on their inherent treaty and land rights. The Manitoba Métis Federation is also against the bill because it recognizes the Métis Nation of Ontario. Ken Coates is a professor at Yukon University who recently wrote an opinion piece on Bill C-53 for the Globe and Mail. Joins me today from Whitehorse. So, Professor Coates, thanks very much for joining us today on Nation to Nation.
It's great to be with you.
So I notice you make quite a few points in that lengthy article that you wrote on Bill C-53 in the Globe and Mail. Could you maybe just summarize for our viewers maybe a couple of the key points that you wanted to make in the piece?
Well, I guess the key points would be that in one sense it's very frustrating that Indigenous folks are still having to use government processes to deal with issues like identity and legal rights and things of that sort. We're never going to escape that, but it is a frustration that Indigenous folks have to refer to official authorities in Ottawa to get things done. But the main point would be that this is not a straightforward and a very complicated sort of situation. There is in Western Canada this idea that the Red River Métis are the real Métis or the original Métis. Folks in Ontario very much are people of mixed ancestry. They can trace their heritage to Indigenous and non-Indigenous parents over sometimes many hundreds of years now. And the folks in Ontario, through the Pauli case and other legal sort of processes, have been clearly shown to have Indigenous rights, and therefore to have eligibility for treaties and things of that sort. And I guess the last point is that the Government of Canada has, in the last sort of 5 years, been working really hard to sort of get some of the long-standing simmering issues off the table. We've had settlements of specific claims and treaty claims. We've had land claim agreements signed. And this particular one with the Métis is an attempt to take that to the next stage. So the Manitoba Métis were moving in their own direction. This is Alberta and Saskatchewan joining now and sort of having the right to negotiate treaties. And the problem has come up just in a political sense with the Métis Nation of Ontario, where there's more controversy, more debate about what's going on. The folks in Ontario are quite comfortable. They know they have their own processes, their own genealogical research, their own citizenship codes. They have that down. And they're kind of very frustrated that the rest of the country is having trouble just accepting their interpretations as being appropriate and fair. So it's gotten heated. You know, you have situations where the Assembly of First Nations is leading complaints against the Métis Nation of Ontario. A lot of the First Nations in Ontario are questioning sort of the legitimacy of the Indigenous rights. And the Métis in Saskatchewan and Alberta, most of whom trace their heritage back to the Red River Métis, are sort of anxious to proceed as quickly as possible.
Yeah, so just moving to the Métis Nation of Ontario and sort of the conflict that we're seeing with the First Nations here in Ontario, that seems to be the bone of contention. How do you think the government might have been able to draft this legislation differently that it didn't lead to this or was maybe a little smoother than what we're seeing?
So I was perplexed when the bill came forward that you put the three together. The Manitoba was already on its own path, and you have these three provinces taken out and putting them in an omnibus arrangement. It makes it easier, more convenient for government. But you know, Saskatchewan's not Manitoba, and Alberta's not Ontario. And so in one sense, it could have done it easier, more readily by having sort of a separate process for each of the Métis nations. I like in one sense, the attempt to sort of provide some broad and comprehensive sort of package and approach. And I think there should have been more consultation with Métis and First Nations ahead of time. So much less controversy in Saskatchewan and to a lesser extent in Alberta between the First Nations and the Métis because they've been in discussion for quite some time. Manitoba, the Métis Nation of Ontario, has not had as extensive discussions with the First Nations in Ontario, and those folks very much feel that they've been sort of left out. And one of the really sad things about what's happening with government policy and funding and things of that sort is there is this growing sense that it's a bit of a zero-sum game, that if one group gets some rights, they have to come at the expense of somebody else. You know, so the Métis and the Pauli decision got recognition of their right to hunt. And there was a pushback among a number of First Nations saying, well, now we're going to have too much hunting on our territory and that shouldn't be allowed to happen. That actually hasn't occurred that I've ever seen in a major sort of way. But it does reinforce this idea that what one group gets has to come at your expense. And when you have Indigenous groups and communities that are striving for social and economic equality, that are dealing with a whole bunch of historical legacy issues from residential schools and Indian Act rural regulations, the management of reserves and the old Department of Indian Affairs, they really believe and worry that if somebody else comes on the scene and gets more power and more rights and has access to government money, that it's going to come out of their pockets.
How about the word treaty? That's in the legislation. Do you think that should be included?
I think so, because I think first off, when you look at the Section 35 of the Canada Act, it basically says that Section 35 says we're respecting existing Aboriginal and treaty rights. So treaty rights have constitutional protection. So when you have a self-government agreement that's signed between a First Nation and the Government of Canada, it becomes a treaty that is therefore constitutionally protected. And quite frankly, if I was an Indigenous person, I would look at these issues and say, you absolutely have to have that constitutional protection. You know, governments come and go, policies come and go, funding changes, et cetera, et cetera. You First Nations, Métis people, Inuit people need a constitutional guarantee. They need to know that they have the full force of the Canadian legal and political process behind them. So including the name of treaty, it does raise the stakes. It gets a lot of non-Aboriginal people worried about, well, how many of these are you going to sign, all that kind of negative backlash stuff we've heard for many, many years. But from an Indigenous point of view, you know, if you don't have a treaty, what you have is an agreement. And if what you have is an agreement is subject to political processes, to sort of being defunded down the line, or have the government change its mind and go in a different direction. So this is hard stuff, and it should be hard stuff, because you're actually laying the new foundations for Canada in the 21st century. You know, we've done an awful lot of those. We've had a lot of modern treaties signed. None of it came on board. We have self-government agreements. There's 100 agreements. I think it's like 60 have been signed, and about 40 of them are in negotiation. We are changing the very rules and foundations of Confederation. So let's do it right. There'll be arguments. There'll be debates. You know, I'm talking to some people who say, "Oh, the First Nations, Métis can never get along." I said, well, have you ever talked about Quebec-English relations for the last 100 years? Have you ever looked at sort of at constitutional reform, like the Meech Lake Accord, and saw what happened to that? Non-Indigenous people have big arguments and debates over constitutional affairs. Indigenous folks exactly the same way. But you're building the country, so let's build it properly.
Right, and unfortunately we're going to have to leave it there for time reasons, but very interesting piece of legislation, obviously, and we look forward to seeing what happens with it. And thanks very much again, Professor Coates, for joining us today.
You're more than welcome. Take care.
Up next, we'll have Dr. Lana Potts, who will talk to us about a new study on behalf of Deloitte Canada that looks at Indigenous youth and mental health initiatives.
Hello, I'm Rick Harp, host of APTN News Brief, a daily podcast version of the nightly broadcast of APTN National News. Available on all major podcast platforms, APTN News Brief is your quick way to hear the headlines every weekday morning. Learn more at aptnnews.ca/podcasts.
You're watching Nation to Nation, and I'm Fraser Needham. Deloitte Canada has recently published a new report that looks at ways Indigenous youth may improve their mental health and begin healing journeys. It's called Breaking Colonial Legacies and Mapping New Pathways to Mental Wellness. Joining me today to talk about this report is Dr. Lana Potts of Deloitte Canada. Welcome to Nation to Nation, Dr. Potts.
Hi, thank you for having me.
So I thought I might ask you first off, why is Deloitte involved in this type of work?
So this report is part of their series, their reconciliation plan. And Deloitte is actually really invested in doing reconciliation internally and looking at what they can do as a company who invests in Indigenous people, who have Indigenous partners and work within our country. They've looked at how do they improve. And in order to improve that, they've done a series of investment into community around education and empowering themselves as an organization to be leading with a reconciliation plan.
And I guess if you could briefly tell me as well, what were some of the key findings of the report?
So the key findings was really looking at mental health. Mental health, as we know, is probably not spoken up as openly as physical health or other parts of ourself. And so it was an idea of going to talk with the youth and to hear their voices, to hear what is concerning them and what do they want heard. And so the idea was really going back. And some of the key findings were, when I say going back, was what they talked about was going back to where the roots of strength were from. So the idea is that one is they do have poor mental health. Mental health race, this is embedded in our intergenerational trauma. The traumas that we have suffered as Indigenous people have a huge impact on them. They carry a heavy burden of racism. They carry a heavy burden of having difficulty with identity, having difficulty with language, and their ability to access their own ways of healing.
Right, I thought I might expand upon that a bit. Why is that? You obviously heard this back in the report. Why is that so important for Indigenous youth maybe experiencing some mental health challenges, that there be a cultural component to this?
We know through evidence that what kept us well prior to contact was our ways of knowing, our idea of understanding of who we are. Personally, it wasn't about 10 years ago that I wouldn't even have introduced myself as a Niitsitapi, that my identity and who I am has allowed me to be able to even speak here today. But with youth, that's really important because it has, through their voices, they've stated it allows them to feel proud. It allows them to hold their heads higher, to acknowledge where they come from, acknowledge their language and their ancestors. And we know that evidence around being able to say that I'm Indigenous and I'm proud is linked to better mental health. It's linked to decreased rates of depression. It actually is protective against suicidal ideation.
Now, I noticed it also highlights online activity, right? That some of that started with the pandemic, of course, of people accessing mental health services through Zoom, things like that. Now, it mentions this as a potential thing that maybe could be a benefit for Indigenous youth accessing these services.
Yes, that's actually very true. But one of the realities is the broadband access. So what came out in the report was a bit surprising to me, that only around 40% of our communities have access to broadband. But those that do have access, this has been a significant in terms of avenue for them to be able to access services. Because one is they could, talk with somebody, they could make a telephone call, they could actually create an appointment. So this was one of the recommendations, was to address the broadband issue within the community, to actually link services, because we realize that a human resource, we're low in human resources. It's hard. There's not enough of us to do the work. As a physician, we know primary care access is another issue within our community. So we need to be able to provide all avenues in order to access care.
Now, you're probably aware that as part of the Canada has a connectivity mandate, and part of that is reaching out to making sure that communities, like Indigenous communities, have this remote access to decent broadband services. And that, do you see that we're moving toward that, or is the government really still have a lot of catch up to do?
I can tell you from the work that I do that there is a lot of catch up to do. I know that a lot of communities don't even have basic telephone service. So I think there needs to be an investment in towers, communication towers. And that's what this report really speaks to. It's really around removing barriers. It's around, I think we're at the point in our country, reporting our history, where the reports are, there's many, we know what we need to do, and we need to start to listen to these voices that are saying, we're giving you simple solutions, such as putting up a tower, providing access, investing so we can actually, make a phone call and get on the internet, as most services have gone online.
Now, of course, we're in a time of strained healthcare dollars at all levels of government. Any idea how much some of this might cost, just to sort of get the ball rolling, I suppose, for governments at any level to make a difference in mental health services for young Indigenous people?
So we know that healthcare, there needs to be significant investment in healthcare on all levels. Around mental health, it's estimated that some of the data puts out that there's a burden of over $50 million on the economy that is strained due to mental health, depression, PTSD, and loss of access to services. So it would look to be at minimum of that, of 50 million or more. It's hard to say with the number of nations. I wouldn't be, I would say at minimum to start with a $50 million investment at different levels, the federal and the provincial levels, to really start to look at key projects, ones that are successful, but also investing in communities that actually are starting from, just a basic foundation of services.
Okay, well, we're going to have to leave it there, but interesting report, and we look forward to seeing how it shakes out at the, at the government and policy level. And thanks once again for joining us today.
Yes, thank you for having me. I appreciate you allowing me to speak.
That concludes this week's episode of Nation to Nation. If you missed any part of tonight's show, you can check out our podcast at aptnnews.ca/podcast. I'm Fraser Needham. Good night.
Hi, I'm Dennis Ward, host of Face to Face. Coming up on our next episode, I'll be sitting down with award-winning playwright, author, and broadcaster Drew Hayden Taylor. We'll be discussing his new novel, Cold, the upcoming season of Going Native, and much more. Tune in Tuesday on APTN or listen to the Face to Face podcast. Download and subscribe on your favorite player.